Most oftentimes when you hear about fraud in workers' compensation, you're hearing about injured worker or employee fraud. Purportedly, employees or injured workers make material misstatements about things that they do or do not do to obtain benefits. When that happens, the defense attorney and or the district attorney tries to use insurance code section 1871.4A1, which states it's unlawful to do the following: to make or cause to be made a knowingly false or fraudulent statement or material representation for the purpose of obtaining or denying compensation, as defined in section 3207 of the Labor Code. When we had the reform, Senate Bill 899, that was pushed through with Governor Arnold Schwarzenegger's popularity on April 19th, 2004, we were told that we needed to reform a system to promote uniformity and fairness because of injured worker fraud, which at the time was talked about being less than 1%. So we reformed a system for less than 1% of the claims. What we have never heard discussed and what we never hear talking about is insurance code sections 1871.4 A2 and 3. A2 and 3 say to present or cause to be presented a knowingly false or fraudulent written or oral material statement in support of or in opposition to a claim for compensation for the purpose of obtaining or denying any compensation as defined in section 3207 of the Labor Code. And 3, knowingly assist, abet, conspire with, or solicit a person in an unlawful act under this section. Those are important distinctions because those apply most generally to insurance companies and employers. I see this in representing injured workers every day, and these are never pursued. Specifically, just looking at the internet today, looking at the Work Comp Central site, which is a site, very informative site that many people in the industry use to look at, but is run by people on the defense side. I believe the person who started is a claims manager or former claims manager or claims representative of some kind on the insurance defense side. But I may be incorrect. I don't believe it was started by an injured worker or anybody representing injured workers. And I'm confident in that statement. One of the headlines today on that side of the 3 that have to do with California is the Ratings Bureau says that there's a roller coaster in workers' compensation system as it remains uncertain ratings, that the High Court, California Supreme Court, denied review of the board's en banc opinion on penalties. If you remember, Senate Bill 899 purportedly increased penalties by making them 25%, but the underlying language was 25% of only the delayed amount, not of the entire class of benefits as it was before. So if one doctor appointment at $150 was delayed, then 25% of $150 is the penalty, whereas in the former law, it would be 10% of the entire class of medical benefits. So if you had had $100,000 of medicals to that date, the penalty was $10,000. So insurance companies took it more seriously. Under the current law of 25% of only the delayed amount, insurance companies don't take it very seriously. But at any rate, number 3 on the list is Nevins, meaning Carrie Nevins, the administrative director of the DWC, acting administrative director, revising PDRS, Permanent Disability Rating Schedule, quotes, not currently prudent. Apparently, Ms. Nevins has taken the position that it wouldn't behoove the state of California to update the permanent disability rating schedule at this time, presumably based on increased cost to employers. This is a problem because the updating of the permanent disability rating schedule is required by law. The Schwarzenegger administration, in pushing through SB 899, changed the PDRS, the permanent disability rating schedule, to be based on loss of future earning capacity. And in the law it said that every 5 years the schedule had to be updated to account for different loss statistical studies showing losses for different body parts for different types of injuries over periods of time, and it needed to be updated to show people's true loss of earning capacity. By the administration refusing to update the PDRS, they're refusing to comply with the uniformity that they expressly had written into the law and desired. And more importantly, they're refusing to comply with the rule of law. They don't agree that they're under the law. They often do things outside of the law, and they worry about the consequences later. For example, if you're a state worker, this will be close to your heart, when the governor decided to furlough state workers during the budget impasses in the last year. When state workers were furloughed, it was done irrespective of where budgets come from and monies from budgets. It's been since determined by a court that the state workers from departments that are funded by a majority of funding other than the state general fund should be exempt from the furloughs and having forced days off without pay. So the administration, I believe, makes material misstatements and takes material actions to deny people their benefits, meaning their pay in the furlough case, and in the case of the PDRS, deny people their benefits. Arnold, acting above the rule of law, or his administration, and his appointee, Ms. Nevins, lead to a situation where the administration flaunts the law. They willingly make misstatements or fail to comply with the law, denying people benefits. These are important things. So while that's not fraud in the technical sense, it is a situation where the law is not being followed, and that is resulting in the denying of injured workers' benefits. So a lot of the ways that carriers and employers commit, insurance companies and employers commit fraud, or acts analogous to fraud or seemingly fraud, are colored in such a way as they seem quasi-legal or outside of legally accepted actions, but aren't outright fraud. And so these things don't get quantified in the same way that injured worker fraud does, because injured worker fraud is usually a videotape of some person doing something they said they can't do. And the insurance companies have deep pockets. They love to get this stuff on the news. They love to get it in commercials and push it out there to the public to mislead the public, because those images stay in the public's mind. They're great sound bites or video bites that the public can carry around with them to represent a situation or an issue, a complex issue, rather than people discussing all of the ways that employers and the administration itself fails to comply with the law or refuses to comply with the law and commits acts analogous to fraud, or maybe even outright fraud, depending. Recently, there was a speech by John Duncan, the head of the Department of Industrial Relations for the state of California, and I believe he was an appointee by Mr. Schwarzenegger, Governor Schwarzenegger. And in his speech, he talked about nearly 12% of California employers are uninsured. 12% 12 out of every 100 employers in the state of California do not carry workers' compensation insurance. Workers' compensation insurance is required by law for California employers. It's a violation not to have workers' compensation insurance for your employees. And more importantly, it denies injured workers benefits, timely provision of benefits when they are injured on the job. I am one of the few people who take a lot of, or this office is one of the few places that take a lot of uninsured employer fund cases, which means that first you have to track down an uninsured employer, you have to find them, you have to personally serve them, you have to get treatment on a lien somehow, you have to petition, file for a hearing and petition for the uninsured employers fund to be joined to a cause of action, and then you have to ask the state's uninsured employers fund to pay benefits for that employer because they didn't carry insurance. This is a failure to comply with the law. It's a material, not a material statement, but a material action that denies an injured worker benefits. This is action analogous to fraud, but it's not talked about. People aren't convicted for it, and nobody cares. But more importantly to you, sitting at home or wherever you may be, it puts the burden on the California taxpayer to pay additional costs, or our workers' compensation insurance system, or the insurance companies themselves, to pay additional costs to make up for this fund, to pay out claims for employers who do not have insurance. So we have an administration who takes material actions to deny injured workers benefits. We have 12 out of every 100 employers who take material actions to deny injured worker benefits by not having insurance. The administration by not updating the permanent disability rating schedule. And these two things affect far more cases than the less than 1% of injured worker fraud that occurs, according to the then insurance commissioner, I believe it was John Garamendi at the time. So by the state's own, at least in 2004, person regulating such things, injured worker fraud, less than 1%. We now have, by admission of Sean Duncan, the head of DIR, Department of Industrial Relations, 12% employer fraud, just on the basis that 12% of employers are not insured, which is a criminal act. And we have a situation where, on a larger scale, we have an administration who refuses to comply with the law. Many would say that's technically not fraud. And while it might not be, it's still a material action that denies people benefits. And these are the types of malfeasance, fraud, misbehavings that happens on the employer, the administration, the insurance company side that affects the delivery of benefits or denies the delivery of benefits to injured workers. One of the huge reasons, or largest reasons, I wanted to discuss this topic today is recently there has been the development on the defense side in workers' compensation of quote-unquote specialists who advertise to the defense community, mostly insurance companies, to hire them to bombard doctors with letters to lower applicants' ratings, injured workers' ratings, their percentage of disability. Many of these people guarantee that their letters and their bombarding of the doctor will produce a lowered permanent disability rating. There are many of these people now advertising. I think by last count, about 6 that advertise a lot. And this is a huge problem because I often tell people, and I tell people all the time, you need to be represented in the workers' compensation system. If you don't have an attorney, you're going to get taken advantage of in ways that you have no idea is going to happen to you. You don't know that the administration has ordered the raters at the workers' compensation appeals boards to not rate according to case law in Alvarez-Guzman and according to case law in the Ogilvy decision. These are two panel decisions. They were en banc. Now they're significant panel decisions, albeit they have been appealed, but they're good law until they're overturned, even if they're on appeal. The administration is ordering the people who do the ratings at the boards not to follow these laws, these cases, the holdings in these cases. That's important because if you go in with a doctor's report as somebody who doesn't have an attorney, and that doctor says the straight rating of your injury, your back injury, you have a herniated disc, so your disc in your spine has popped and you have pain, but you don't have verifiable radiculopathy, meaning pain going down your leg, because when you had a nerve conduction study or electromyogram, it came back negative for nerve impingement or damage or delayed nerve conductivity. Or you were denied the nerve test in the first place, and some panel doctor who drives around the whole state or flies around the state doing exams said you didn't need one, and because on exam he didn't think you had pain going down your leg or you failed to mention it at your exam. Based on that, that gives you a diagnosis-related estimate rating of a category 1. That could be between 0%, or a category 2, which could be between 5 and 8%. Even if the doctor gave you the 8%, the highest range of the DRE2 category, that wouldn't be a lot of money. You'd be looking at, $5,000, $3,000, and then maybe something for future medical treatment. So you may have lost your union job. You may have lost your job as a roofer, making $20, $30 an hour, or a carpenter making $20, $30 an hour with your benefit package, sometimes up to $50 an hour. You lost your pension. You lost your health benefits. So you lost your life. We no longer have job retraining in California since 2004. So you don't get trained for another job. You get a coupon or a voucher for some vocational services, but it's not vocational rehabilitation the way we used to have it. And most people use the voucher to obtain some kind of equipment like a computer or something, but that's not going to give you a new job. So you have a situation where you've lost all this and you're going to get $3,000 to $5,000 for your injury. Well, that same doctor's report may have said under Alvarez and Guzman that because that straight rating of the AMA guides, the American Medical Association guidelines, was not adequate to account for your future loss of earning capacity. And the doctor therefore then rated according to another table within the guides, such as a hernia table. Maybe the doctor said you had a class 3 hernia, so they thought you had a 25% disability, which then gets adjusted for your age and occupation. That could be up to a 35% disability, depending on how old you were, or were at the time of the injury, and how heavy your occupation is. $35,000 or 35% disability could be anywhere from $35,000 to $40,000 because the schedule is progressive. It goes up as you get higher numbers. And that's a huge difference, even though that's not adequate money and that's not fair money. That's huge difference compared to 3 to 5% or even 8% based on a straight rating of the AMA guides. But if you're at court without an attorney and you're in the hallway, the attorney says, defense attorney walks out to you, the insurance company's attorney, not the employer's attorney, because those attorneys represent the insurance companies. And he or she walks out to you in that hallway and says, here's an official rating from the state, the DEU, the Disability Evaluation Unit. And the DEU rates your report at a DRE2 at 8%. And so this is all your case is worth. They don't tell you because they have a duty to their client, not to the truth, not to justice, not to the American way. They have a duty to their client to defend their client, and they're going to tell you this is what the state rating said, which is true. They're not going to tell you, but there's a whole nother way to rate your case based on the doctor's report, that the governor has ordered these raters not to follow, which should be illegal and flaunting the law, just as the way the administration has in not updating the schedule in the first place. But they don't tell you that this illegal activity has denied you your right to know that your case could be worth a lot more money. And they're not going to tell you that because they don't have a duty to tell you that. That's not their responsibility. So by not having an attorney, that's an example of something you just cannot know. So if you pay an attorney in workers' compensation cases 15%, 15% of $35,000, $40,000 is a lot less than only taking 8% for your injury. The money you will have been making will more than make up for the attorney's share. So the compensation system is so complicated, it behooves everyone to be represented. Anyway, so those are two more ways the administration ordering the raters, or another way the administration ordering the raters not to follow the Alvarez-Guzman decision and do ratings properly, robs people or denies people benefits on a daily basis all over the state of California. There are hundreds, thousands, maybe hundreds of thousands of injured workers at the various boards throughout the state every day who get handed ratings in the hallway without being told that this rating doesn't include the rating of the additional doctor's language under Alvarez and Guzman, and it's because the governor or the administration has ordered the raters not to do this. So you will not know. But that's another example of this employer, insurance company, administration, quasi-fraud conduct that denies injured workers benefits that happens every day that you don't hear about. So you've got 1%, according to John Garamendi, the insurance commissioner, worker fraud. You've got, according to the most recent speech by John Duncan at the DIR conference, the head of Department of Industrial Relations, it was in Oakland. According to his speech, 12% of employers aren't insured for workers' compensation. So that's 12% fraud right there. So you got less than 1%, 12%. Then you add on the administration as a whole is denying the whole system an update to the permanent disability rating schedule. I don't know how you would quantify that in a percentage. Then you add on to that, every day injured workers are defrauded or denied benefits because of material misrepresentations by the administration, because the administration refuses to provide ratings in accordance with the law. So I don't know how you would quantify that, but there's a whole bunch more percentage of institutional administration, carrier, or employer fraud. So you've got all that against 1%. Now there's this new phenomenon where there are these people advertising to lower ratings. Recently, I had a trial in what is called a alternative dispute resolution or carve-out case. The carve-outs or alternative dispute resolutions is a system allowable for employers to group together to have a system that's under the workers' compensation laws but is done privately. And purportedly this is to streamline efficient delivery of benefits to injured workers, because the workers' compensation system and the local appeals boards have been so backed up and backlogged with filings and with changes in the law that they've become cumbersome. And it takes, sometimes in the Oakland board, where I'm most often, sometimes it takes 6 months to a year to get a hearing on an issue. And many times people have been suffering without money or without treatment for that time, or by the time the hearing comes around, they receive the treatment very late, and it's become a moot point. So in order to get around that, these ADR systems were established. But what they've really morphed into is a denial of due process for injured workers. What happens is injured workers, through their unions and through their employers, are basically allowed to bargain away their rights to fair representation and due process. Well, what do I mean by that? Well, for example, at this mediation trial or arbitration trial on Wednesday, there was another, we held it at a hotel with a private arbitrator. When we were done and we were leaving the room, the ombudsperson, who's supposed to be a go-between between the injured worker and the insurance company to help answer questions and help benefits flow, the ombudsperson was hurrying us out of the room, and I asked her what was going on. She said, well, they had another arbitration right after we left, and they needed to get us out of the room to get that one started because they were doing multiple arbitrations while they were in Northern California that day, because these people were all from Southern California. Well, so I said, do I need to stick around to help out this injured worker since I'm here? And she said, no, our system means that people aren't supposed to have attorneys. Well, that's not true. Some of the ADR systems say you can't have an attorney till your trial, or you can't have an attorney at all. But this particular system, it was in the rules that people were allowed to be represented. So here was a material misstatement that's denying an injured worker benefits because this person, who's the ombudsperson, supposedly following the rules and making sure everybody follows the rules in this alternative system, kind of like a neutral observer or the information and assistance operator at the officer at the Workers' Compensation Appeals Board, this person saying, no, our system's designed where people don't need to have attorneys. Well, that just means so injured workers can be taken advantage of, so they can be denied due process, and so they can be denied benefits. Let me give you an example. In the case I was at, there was a filed as Exhibit 3 a letter by a rater with an analysis of the doctor's reports. It was a psychological case. We had a defense psychological report, and we had a plaintiff or applicant psychological report for the injured worker. And this purported rating person wrote an analysis basically where he went behind the medical determinations of the doctors and said why their conclusions were wrong and what their conclusions should have been, and then based on what he thought their conclusions should have been, what the ratings should have been. So he cut the ratings to about a third of their value by this process. So the insurance company wouldn't pay a dime above this amount. I objected to the document being entered as Exhibit 3 for the trial because raters are only allowed to value the medical report the way it's written. They are not physicians. They are not doctors. They were not official doctors who examined the person in the case and reviewed the totality of the medical record and gave an opinion based on all of this information and their experience and expertise. But instead, this person was trying to be a doctor behind the back of both doctors and try to come to different conclusions. Well, there are people advertising that are doing this stuff on a daily basis throughout the state. I was in court about 2 weeks ago at the Workers' Compensation Appeals Board in Oakland, and in one of the courtrooms, one of the judges had found a whole bunch of these letters to a doctor in a case. And she asked defense counsel in the case, defense counsel, were any of these letters sent to the injured worker? Because the injured worker was unrepresented, what we call in pro per. And the defense attorney said no, the person was not served with a copy of all these letters. And the letters had served to significantly decrease the value of the applicant's rating, the injured worker's disability rating, because this particular rating expert was telling the doctor that they had to follow the new schedule for rating disability and that it had to be rated in such and such a way. Well, it wasn't true. The judge pointed that out to the defense attorney, told him to go outside and offer this applicant, injured worker, real money based on what it should have been. Well, that was because this particular judge was diligent. This particular judge took her job seriously. This particular job was worried about an injured worker being taken advantage of. Some judges would not look at a file that closely based on how well they know the defense attorney, and they would just authorize the settlement. This injured worker would have been taken advantage of, and they would have had no way of knowing they were taken advantage of. And more importantly for today's discussion, they would have been taken advantage of in such a way that I think meets the definition of fraud. Again, when we read insurance code section, instead of A1, if we read A2, A2 says, present or cause to be presented knowingly false or fraudulent written or oral communications for the purpose of obtaining or denying, not just obtaining, denying compensation benefits as described in the labor code. Well, this was a clear case of a written communication that was false, that was meant to deny an injured worker benefits. So in both the case that I saw in open court and my arbitration more recently of this last Wednesday. So I think it's important for injured workers to be represented because there is a lot of fraud out there in the workers' compensation system that has nothing to do with an injured worker, but all impacts the injured worker. So now we have less than 1% on the injured worker side. We have 12% of employers uninsured. We have an administration that refuses to comply with the law and update the permanent disability rating schedules based on studies of people's loss of earnings. We have an administration that's ordering the raters at the different boards to not follow the law in California, the Alvarez and Guzman decisions, and not rate medical reports under those decisions. And we have numerous people in the defense community advertising out there that they will write to doctors on the behalf of insurance companies and beat on the doctors to get them to lower their ratings of the injured worker's disability, thus lowering the amount of money that has to be paid out to the injured worker in such a way as it amounts to fraud. They're material misstatements or incorrect statements in writing, written communications to deny injured workers benefits. And all of those add up to somewhere between the 12% baseline for the uninsured employers and some higher number. And either way, that's a lot more than less than 1%, according to Insurance Commissioner Garamendi in 2004, of injured worker fraud. Now, it's not as sexy to talk about an administration that doesn't follow the law. It's not as sexy to talk about defense people in the defense industry writing to doctors to bang on them to get them to lower ratings and money to injured workers. Those things don't lend themselves to video clips. Those things don't lend themselves to nice sound bites, but they are important problems within the community that people need to be aware of, and they amount to a much higher rate of fraud or fraudulent type activity than is commonly discussed. Now, looking at workcompzone.com today, I note that there is an article about exactly one of these types of seminars, and I'm not going to name the person, but there's a seminar in San Francisco today where somebody offers these types of services to insurance companies. So this isn't something that may have happened a couple times, and it just so happened to happen to me Wednesday in a case. And I happened to hear about it in an open court in a case last week. But this is something that's ongoing and happening every day. And injured workers need to be aware of it, and they really no matter how bright you may be at doing your job, whether you were an engineer or a baker or an auto mechanic, the system is so sophisticated that you can't know these things are going on unless you're part of this system and unless you do it every day. And just like I wouldn't go to a baker to fix my car, or I wouldn't go to a mechanic to bake me my daughter's wedding cake, you need to go to an attorney who specializes in workers' comp, who knows that these things are happening, so that you can get proper representation. Now, not all attorneys may be as diligent. They may not all be as knowledgeable. So one way you can, at least in workers' compensation, kind of get an idea if you're getting somebody who does this for a living, you could contact the California Applicants Attorneys Association, or you could contact the National Organization of Injured Workers, and they could point you to somebody who does practices workers' compensation for a living and who know these things and what's going on in the system on a daily basis. Hopefully that little bit of information will help injured workers and help people be more informed about protecting their rights and maximizing their recovery on the unfortunate occurrence of a work injury and a loss of ability to earn because of their work injury.